So hello, everyone. We're going to get started, and just in case a couple other classrooms pop in, we'll allow them, but oh. Can you guys hear me? Oh, there we go. Okay, it froze on my end. So hello, welcome everyone. Today's presentation is on eviction prevention. So listen up, and this is Bob and from Law New York, and he will present to you guys. If you have any questions, you can either speak up or you can write it in the chat box and I will address them. So the floor is yours. Still muted.
Not the first time that happened. Good morning, everybody. I'm Robert Vitale. I'm a supervising attorney at a Legal Assistance of Western New York, Law New York's Eviction Prevention Unit. I've been in this position for going on 20 years, and I co-supervise the unit with my colleague, and we have 12 individuals that are working with us to address housing crisis needs, but also to address issues regarding income supports, so public benefits, food stamps, unemployment, etc. So thank you for having me this morning. I am going to try to present, share on the screen. I've successfully done in the past, so hopefully we won't have an issue this time around. Let me try that first. Okay. Do you all see the Know Your Rights present PowerPoint?
Yes.
Excellent. Okay, so this is a PowerPoint presentation. Well, let me just start off by saying, listen, I relish questions. I want this to be as interactive as possible so that you folks out there who are listening can have your questions answered if I'm able to, or express your perspectives or opinions. So by all means, you can interrupt me because I can go on and on droning on to my own voice, and that would be quite boring for all of us. So please, if not, then you can save your questions to the end, and we'll leave enough time to answer any and all questions. So thank you. This is a presentation that's been updated, as you see, January 28th. There have been updates since that point in time. In fact, just this past week in regards to some protections for tenants in New York State from being evicted, and we'll get through that. But most of this is, at least relevant knowledge to you. The first section is going to talk about some of the COVID-related protections for tenants that had been passed either by the federal or state to stem the housing crisis, to keep people in their homes while the pandemic has played out. I'll also go through some basic statutes, some basic rights and obligations tenants and landlords have in New York State that might be relevant or interesting to you. This involves the COVID-19 Emergency Eviction and Foreclosure Prevention Act of 2020 was signed into law at the end of last year. And we'll go through this, but I will note to you all that this had been just extended out until August 31st. And that was signed into law, yesterday, I believe, by Governor Cuomo. In essence, what it does is that there will be no evictions for individuals who qualify for signing what's known as a hardship declaration. And there's a particular form you can find online with our office, or if a landlord is attempting to terminate a tenant, the landlord has an obligation to also serve this form. And in essence, it states that if anyone had been financially impaired as a result of the pandemic, in some way that the pandemic had caused financial trouble, then, or if there is a difficulty finding an apartment, getting moving expenses to relocate, then a person would qualify for signing this hardship. Once submitted by the tenant, signed and submitted to either the landlord or the court, then no eviction can take place until now, since the governor signed it yesterday, until sometime after August 31st, 2021. So you may come across news articles or on the news, on television itself, saying that there's a moratorium on evictions until August 31st. Well, this is what it is. But in order for that to be in place, if someone is being threatened with eviction, then the hardship declaration needs to be signed by the tenant. And you see on this slide the types of eligibility factors that a tenant can qualify to sign this hardship declaration. I mentioned moving expenses, difficulty securing alternative housing are among the factors. This is the form itself. As I said, it can be found online through our office, or if someone is being threatened, the landlord must serve this on the tenant. Now, the New York State Tenant Safe Harbor Act, I'm going to just gloss over this real quick because it's really been it's really not as relevant now because of this law I just spoke about with the hardship declaration. But last year, at the height of the pandemic, at least during the summer of last year, this went into effect to try to prevent evictions in New York State. And you'll see some of the same factors that were covered. This Center for Disease Control and Prevention, this is the federal government. Now, what I just spoke about with this moratorium to August 31st of this year, no evictions if you sign the hardship declaration, that was state. This is federal. And the federal government has implemented their own protections on top of the state. So these are minimum guidelines that all states must follow through with. And what it does is it halts evictions, much like the state moratorium. It halts evictions through June. You can see on this slide, it protects it from evictions for non-payment evictions until March 30th. It's recently been extended through March 31st, but then it had been extended through the end of June. For us who represent tenants, we're really relying on the state because the state law is allowing protections through the end of August now. But there are federal protections. Utility companies cannot shut off your utilities. And you see this started early on in the pandemic. But if someone is facing a utility shutoff, then there are processes from which to have that restored. And so if you or anyone you know is facing a utility shutoff, there's an opportunity to give our office a call and we can assist. This was another pandemic related statute. Landlords may not collect fees for late payment of rent starting March 20th of last year. This was effective through January 29th. That has been extended. Now, they could charge, but they can't collect. And so if there's a late rent fee provision in some tenant's lease, the landlord cannot take that money currently. There are a lot of people that are in financial crisis right now, and have been for a while. And there are a slew of people that are behind in rent for various reasons as related to the pandemic. And we'll talk about some financial assistance programs that are out there to assist folks who are behind in rent or having difficulty paying rent now and in the future. And we'll also talk about resources available for first month's rent and security deposit if someone's deciding to move. But under the moratorium, it is not a, it's not a situation where people aren't obligated to pay their rent. And I think early on in the pandemic, folks were, understandably under financial crisis. And then there were conversations about whether rent was obligated to be paid. I'm here to say that even now through August 31st, under the state law, that there is an expectation that rent will be paid. There is an expectation that if rent isn't paid, that rent is still owed. And that's why some of these assistance programs were funded by state and federal government because of tenants who are vulnerable and still owe that rent, because that rent is still accumulating if it's not paid. And you see the last point here, once all moratoriums are ended, you can be evicted for rent that you didn't pay during the moratorium. And that's kind of what I'm talking about, unless you have a defense, and we'll talk about some defenses. But if you're behind in rent, or someone who's behind in rent, we need to link you up with or the folks that up with the financial assistance programs before you go into court, because no one wants to go to court under these circumstances. Well, that's a general overview of the current state of the law in regards to the pandemic moratorium. I'm going to stop now and see if there are any questions that I may be able to answer.
Again, feel free to speak up or write in the chat. Could you provide the definition of a hardship and a moratorium?
Good question. We'll start with the moratorium. Moratorium is, in essence, it is saying that evictions are prevented from being enforced until August 31st. So no evictions until after August 31st under the law. But as we stated, that only is the case if someone files the hardship. And let's get back to the hardship slide. The hardship is a document that was created by the state legislature. And it says that if you qualify, you sign this hardship form, submit it, and you will have that protection from being evicted. You won't be evicted or forced to go to court until after August 31st. So let's talk about what qualifies as a hardship. What is a hardship? Well, under the form, a loss of income during the pandemic. Let's say you got laid off from your job and you had a gap in income, and that caused someone to be able to pay the rent that they're being alleged is owed. Well, that's a hardship. Did you have an increase in out-of-pocket expenses as a result of the pandemic? Did you have to, well, I mean, in the next slide, I use that as an example. Children, did you have to pay additional expenses for childcare? Or perhaps you couldn't find, you didn't have childcare because of the pandemic, and that caused you caused you a loss of income. That would be a hardship. There are many folks that we've encountered that parents or a single parent who didn't have access to childcare and had to give up their job or cut down their their hours because of the pandemic. That would be a hardship. Moving expenses. If you were forced to move because you're behind in rent or because they didn't renew your lease, the landlord, and you would have difficulty paying those moving expenses or finding other housing, that would be a hardship. Finding other housing right now and in the past 13 months is extremely difficult. Not to mention, there is increased rent burden. I had read an article where Rochester in the past year is one of the most expensive, well, I should say, let me back up, had one of the most largest increase in rent burden over the past year. And so meaning apartment prices are going up. So would it be a hardship for someone to either move or find another apartment that's within their financial means? Well, if the answer is yes, that would be a hardship. Well, then you qualify to sign this form. Moving would cause a significant health risk to you or your family who are moving with you. That would be a hardship. If you have had COVID or COVID-related symptoms persist and you can't move as a result, that's a hardship. Or if there's other underlying disabling conditions that you or your family are experiencing that would make a transition now during the pandemic an issue, that would be a hardship. So it's rather broad, and I want folks who are on this call or that you may know, family, friends, or others who maybe in a housing crisis to understand that this is something you may qualify for, and it's a broad definition of what a hardship is, and you have to look into your own circumstances to see if you or others qualify. Good question. Other questions? Okay, let's move on. All right, so this starts our Know Your Rights portion of our presentation. All right, the warranty of habitability. Listen, in every lease, whether it's verbal or written lease between a landlord and tenant in New York State, the landlord provides a guarantee. That's what a warranty is. The landlord provides a guarantee that the apartment or home will be livable, safe, and clean. And so it doesn't matter what's contracted for and written down, that landlord guarantees that in every landlord-tenant relationship. And it is possible, if that guarantee is not fulfilled, if the landlord doesn't hold up their end of the bargain, doesn't do what they're supposed to do, then there are options for a tenant. And one of those options is to withhold rent if the landlord, as it says in the slide, refuses to make repairs or fulfill that guarantee. And we can get into that. I will note, though, if someone is in a position that there is unsafe living conditions, that it's always advisable to speak with an attorney before you decide to withhold rent, because there are specific procedures a tenant has to follow if they're going to protect themselves when they withhold rent. And we don't want a tenant to get in a position where they're withholding rent, but they're doing something wrong that could jeopardize their housing in court. So, but this is a guarantee that the landlord makes sure that they make repairs and they provide a safe and clean home for their tenants.
Could you describe what a lease is and what that would entail for protections?
Yes. Well, a lease typically is a written document between a landlord and a tenant. And that document is a contract, just like any other contract somebody enters into. The landlord's providing, in this contract, the landlord's providing an apartment or a home that they own. A tenant is being provided right to possession or right to live in that home. And that's basically it. And in most leases, there are certain provisions that are certain terms that are written down in the lease that the parties, that the landlord and tenant agree to follow. And the landlord agrees to provide, let's say, a refrigerator and a stove. The landlord agrees to mow the lawn, for example. The landlord agrees to make sure that there's utilities are in safekeeping, you know, that they're working, for example. The tenant, in a lot of these contracts, these leases, the tenant agrees to pay a certain amount of rent in that contract per month, typically. Tenant agrees to usually provide a security deposit, and it'll be in that contract. The tenant agrees, a lot of times it will talk about noise. You know, the tenant agrees, we will not make a lot of noise that will disturb others. So that is typically in these types of contracts. There's gonna be a lot of things in a lot of terms in that contract that the parties, that landlord and tenant agree to. But generally speaking, it's a document, it's a contract that the landlord and tenant sign, agreeing to rent the property, and agreeing to for how much the rent's going to be, and agreeing to abide by certain behaviors, typically, to make sure that that the tenant or the landlord is not disturbing others. Good question. Anybody else? This is fun, right? I'm having fun. The right to privacy. A lot of times we, as attorneys that work with tenants, we have tenants that complain that the landlord's harassing them or not coming into their apartment without prior notice. Well, New York State says the landlord can't do that. The landlord must give notice to the tenant that they're going to enter the premises, that they're going to enter the apartment. You know, whether it's for repairs or to show the house, to a buyer who's might buy the home. But the tenant is entitled to notice from the landlord that they're going to enter. This is the tenant's apartment. This is where their home is. It's where the tenant lives. And it's not right and it's not legal for a landlord to barge in, to enter without providing notice. In New York State, typically at least 24 hours notice is required. That should be in writing. You should receive a notice from your landlord at least 24 hours before that says, I need to enter this premises to make repairs or to show the house. If that notice is not given, the tenant generally is not required to allow that landlord in. It's as if someone was trespassing. So it's not a small thing. And it's not, unfortunately, it's something we encounter all the time. So understand, if you were someone who you know that's having difficulty with a landlord who's coming into the apartment unannounced without notice, that's not right, and there can be a refusal for entry. In fact, that kind of harassment continues, there are resources available like our office to try to address that. Now, if there's an emergency, that's a little bit different story. If there's a burst pipe, fire, God forbid, then then those are extraordinary circumstances. Those are that then this rule would not apply. Someone has to come into the house to make the repairs or put out the flooding or whatnot. So, but generally speaking, tenants are entitled to 24-hour notice.
We did have a question saying, during the pandemic, is rent increased okay?
Hannah, can you repeat that, please?
Is increasing the rent during the pandemic okay?
Oh, that's a fantastic one. Because we're seeing that a lot as well.
Can you hear me?
Yes.
So it's a little bit more to that question. So it's a two-part thing. So number one, my landlord, I have two situations. My landlord, he's typically a okay guy. You know, I've been there for 3 years. I mind my business. But what I do is that if he doesn't fix it, I fix it. I paint my own home. I planted a garden. And it seemed like every time I'm doing it, and I understand, I guess the value is increasing. So he's increasing my rent. And it's like, well, is that typically okay? And especially during the pandemic, like I'm to the point where I'm in Oasis now because I took time and I sat down for my job. I came to get my certification. And then after that, I'm trying to go further. So I had to take a step back. So all I have is my self-employment. So, and that's neither here or there. So that's the first situation. So let's answer that one. Then I have one more situation and I'll explain it to you.
Well, I mean, the first thing is, I mean, if you're making your own repairs, or you're otherwise increasing, if you're making your own repairs, that you're not obligated to, it kind of goes back to the warranty of habitability we were speaking about. Unless you're contracted to make your own repairs, then that's the landlord's obligation and not yours. And quite frankly, in situations, and if it's set up properly, meaning prior notice to the landlord and a reasonable period of time elapses, but if it's set up properly, then a tenant could make repairs and then reduce that from reduce the future rent obligation accordingly. But there are steps one would have to follow. So there's that.
And he kind of gets around it because we haven't signed. I say the first year I moved in, we signed a little bit of something, but every year after that, I haven't signed a lease. So it's kind of like month to month, just because I haven't solidified that year. And I'm really not trying to sign a lease because I'm trying to move into a house, a home. Mm-hmm. So when he thinks he's like kind of getting one up on me, I'm not signing on purpose, because when I'm ready to go, I'm ready to go, and I'm not contracted for staying.
So in New York State, there's no real difference except that it's in writing and there are specific terms. But there's difference in how you terminate the tenancy, but there's no difference between a written and oral lease in the sense that it's still a binding contract. You can have a month-to-month oral contract. It doesn't get around the landlord's obligation under the warranty.
Okay.
So the warranty still applies. Every written or oral lease, oral contract for housing, the landlord has the obligation to make sure that it's safe, livable, and clean. And that includes making repairs, unless you have a written contract that says tenant agrees to make all repairs, but that would be highly unusual. And so the landlord has that obligation in your month-to-month contract. And I understand your flexibility and that works for your situation, and you shouldn't necessarily be obligated to enter into a written contract if you don't want to. We can talk about how the landlord can terminate, or you can terminate an oral contract, but that's for another slide. But to your point about raising rent and then raising rent during the pandemic, I think there might be a slide in here that states, and it's a newish law that says that a landlord can't raise your rent for a couple of reasons, but the landlord can't raise your rent more than 5% of your existing rent without proper notice. And if they don't give proper notice, and there's a time frame, and we can get into that if necessary, but if they don't give proper notice, then the rent increase doesn't go into effect. The other reason why landlord, go ahead.
Rent. Every time he has to sign the lease, sign like a lease for DHS so they can see it. like the landlord statement, he'll go, "Hey, honey, I'm raising the rent." That's literally all I get. A phone call, a hey, and I'm like, okay, I get it. So it's like I started there at like 625. I'm now at like 750, 775.
Yeah, so that notice wouldn't be right if, and I'm just trying to do some quick math here. If, let me think here. Let's say your rent was 500 to make it easy for me, right? And the landlord wanted to raise your rent $50 more. Well, that'd be 10% increase. Under those circumstances, the landlord would have to give you a specific type of notice. And quite frankly, it depends on how long you've lived there. If you've lived there, how long have you lived there?
I've been there 3 years and 3 years and 2 months as of next week.
Well, even if the rent was $500 and he wanted to raise it $25, which would be 5%. The landlord would have to give you 90 days notice if you've lived there longer than 2 years for that rent increase to go into effect.
Oh, wow.
Go ahead.
That's new. Oh, no, I'm just saying, oh, wow. I never knew that. I don't get 90 days at all. I get like a phone call.
Well, you got to calculate that 5% out on your situation, because you said he's had gradual increases from 625 up to 7 and change. But if it's 5% on any given time, then you can call me if he tries to enforce that, because it's 90 days for someone who lives in the apartment for 2 years or longer. And there has to be, served on you, et cetera. So that is one defense against a rent increase. So you want to look into that. The other thing is the retaliation. A lot of times especially during the pandemic, we're having folks who are being making claims regarding the condition of the apartment. Complaints that the landlord's not fulfilling their warranty. They're not making repairs. Well, sometimes they'll send a termination notice, right? That's retaliation under the statute that we'll get to. Other times they'll just increase the rent an amount that they know the tenant can't pay, and that's the other way to get around. Well, we will go then for an eviction because you couldn't pay the increased rent. I don't know if that's within your particular circumstances where he's retaliating because of some complaints or because of a discriminatory reason, but if anything falls within those lines, well, then a retaliation argument can be made that the raised rent was as a result of you making that complaint or some sort of discriminatory conduct on the part of the landlord. So those go ahead.
It's kind of both. So basically, I started a self-business. I have two. So I do videos, and then I also do catering. But it's just the sense of him basically seeing, his son personally works with me. He's a very known promoter here in Rochester. So he brings very big guys here. So when I go record videos or when I go host something for catering, he knows what I'm getting paid because he actually hired me. You get what I'm saying? It's his son, but he's dishing out the money. He's kind of one of the biggest money makers in Rochester. So I don't really ruffle his feathers type thing. When those guys are very solidified, well, out through Rochester, you just kind of gotta tread lightly the way you do things. So I keep his home up. I try to keep the noise down, but the noise lately has been getting louder due to I have more business coming in and out. I have more, people outside shooting the video. I have cooking and dishes clashing. And, I have a tenant downstairs that understands what's going on. Plus I have a new addition. I had another child. So it's definitely a noise. So that's number one. But it's he also sees my pockets. You get what I'm saying? He sees through these 3 years, he only lives next door to me. So it's my landlord lives next door to me. So it's it's not a win-win. It's each year I'm paying more and more and more, so.
Yeah, there could be something there in regards to retaliation. If you want to have a conversation offline, I'd be happy to. But especially that notice, at least at first blush, it may be that he's not complying with the law.
Mm-hmm.
And and that should be looked into. And if there are outside third-party sources that are assisting in any payment for you or anybody else on the call, that notice still applies. So if somebody has a has a budget sheet and a landlord tenant statement's being completed for DSS, DSS should be enforcing complying with that statute as well.
Right.
And we're in conversations with them on various projects, but I don't know particularly if they are enforcing that. I can tell you that Section 8, for folks who have Section 8 vouchers, they're enforcing that. We work with them closely and against them when necessary, but we work with them closely. And I presented to them last year about before the pandemic about those new laws and that notice particularly. So it's a great question. I would look into that, ma'am, regarding the percentile. And I'll leave my general number and you can call me if necessary. Okay.
Absolutely. So I have one more.
Yep.
So now that you're actually here, we've been trying to reach you. This is regarding my mother. So the property manager to where I am living now, the one who's supposed to keep it up, the maintenance guy, his mother passed away a couple years ago. My mother said she'll rent from him the house that she was in. So come to find out, she gave him $8,000 for the year. Because she retired from Xerox. She got like basically $250,000. You know how when you're older, you kind of like blow through it. So she gave him $8,000 from the beginning. Now that was number one. I told her she shouldn't have did that. She should have a receipt. She has a receipt. Now she asked him to come fix some things within that home. When we found out he didn't have a CO for that home, on top of that, he has 64 violations within that home. He has infestation within the backyard of that home. And then on top of that, he doesn't have proper ventilation. So then she's still there now. And so the only thing that, when you call the 20131, they told us to get in touch with you guys. We actually went down to the courthouse, and downstairs said it wasn't really a matter for court that they can handle because he didn't owe her anything and she's still living there. But she's trying to figure out how to go about or what to do. The city did say that he's going to end up losing that home because he hasn't paid or did anything to that home. But also, he's a guy that I see every day, coming out of my home, but he's not attending to my mother's home and not fixing anything within her home. So I'm trying to figure out how do we go about it. And I guess that he's a very known person within the system for violations. And it's like, well, how do we recommend? Reprimand, however you say it. How do we get him and get him to either fix or figure out what she needs to do as far as somewhere living different, you know what I'm saying? And they told her don't pay him anything else. So she has not paid for the last couple of months.
Another good question. It kind of encompasses a little bit about what we talked about the warranty regarding withholding rent. And it sounds like your mom's at that stage, right? Withholding rent the past couple of months from the landlord. There's also, and this is a discussion we have, and it's become more prevalent during the pandemic. There is a small claims housing part as well for out-of-pocket expenses that was created in January of 2020, and for any rent obligations that have been paid out during a time when there were violations. And you mentioned that there was 8,000 put down at some point. Now the jurisdiction for that small claims part is 5,000, but that is one avenue that if one wanted to secure the back rent money that had already been paid and there were violations on the apartment, then one can file for $15 or have that waived with the city court clerk and say, I want to file with it's not small claims, general, it's a small claims housing part. And then that case will be docketed. What's important to have under those circumstances is a city code violation report.
Yes.
Because, go ahead.
We went and got it. We actually had them come out again just to recheck everything in the area and see everything that was wrong. Like it's supposed to be a 3-bedroom, only 2 bedrooms is done. It's just it's horrible. It's a part of the garage that's there. It's not supposed to be there. He's like built on someone else's lot, which is door to us. The lady, she's pretty nice, so you know she just let it fly. We make sure we help her clean up her yard, things like that. So we actually have called. I'm gonna get your number and actually really call you because I've been trying to get in touch for a while with you guys because you guys helped me on my first house I ever had. You guys got me all my money back from my trash landlord. So definitely I want to talk way more. Like actually come down, sit down, bring you all the stuff, evidence, all that great stuff.
Well, we'd be happy to talk with you. I will say this, and we'll get into it later. Well, first of all, let's just say yes, we will talk. And then I'll talk to you a little bit all about the project that we're working with collaboratively with Legal Aid Society and what we're focusing on with folks who are in housing crisis. But yes, give us a call. And one last point on this, and then we'll move on, ma'am. If you have a current city code violation report, great. If you wanted to file in the city, in the small claims court housing part, and you wanted to seek back rent money that had already been paid because of the violations, then you might want to contact the city to see if you can get prior violation reports to show a continuum during the time that rent was being paid. So say this started, let's say the rent was being paid in 2020, but those violations were still there. And I want to, if there was a violation report generated in 2020, I want to have access to that to provide to the court. So the court understands this is an ongoing persistent problem and just didn't sprout up when we got the latest report. You follow me?
Okay.
All right, excellent. Thank you.
All right, thank you.
No, thank you, because I think it provided value to a particular situation that folks are on this call or those that they know might be encountering. So thank you. Oh, the right to organize. Listen, we work with, I worked particularly with tenant groups. A lot of them represented by the citywide tenants union, where they're, folks who are living in complexes are experiencing issues with repairs or security, lack of maintenance with their from their landlords or property managers. New York State says, listen, all tenants have a right to organize, and that right can't be interfered with, and so by the landlord. And we talked about retaliation. The landlord can't retaliate against an organizer, a tenant organizer, for organizing. And there are procedures from which, if someone was living in a complex and wanted to start a group, there are procedures from which it would that they should follow to make sure that it can be a recognized group. There's not many formal procedures, but at least some steps, basic steps that would need to be taken. But if there is a complex-wide issue, I encourage it. If there's a need for assistance with organizing that, then there are resources like the citywide tenant union available. And if there is something that needs to be done proactively, I represented the Thurston Road Tenants Association. This firm did, and that was a situation a couple of years ago in conjunction with the citywide tenants union to get into court to enforce that group's right to have safe and livable housing. So it is a daunting task for a lot of people to put their foot out there to take that step because they're worried about retaliation, but there's strength in numbers, and there are resources in this community that are available to walk with you to ensure that, well, ensure is a strong word, but to combat any retaliation that may come come to that group of organizers' way if they want to enforce their rights. Well, I mean, there are two types of evictions. One is a landlord's alleging that a person is behind in rent, and that's called a non-pay. The other is alleging that somebody, it's not about rent, it's that I want the person out for other reasons. Either there was a non-renewal notice, they had a month, or they had a written lease and it wasn't extended. Or there was some behavioral issue or some other violation within that contract that the landlord is alleging that the tenant broke and they want them out. That's called a holdover. So non-pay and holdover. In a non-pay situation, the landlord has to choose one and bring it to court if they want to get possession of the property back. It's not going to be good enough just to say for the landlord to send you a notice to say you have to get out. No, only the court has a right to take possession from a tenant, not the landlord. So if anyone gets a notice from the landlord and says you got to be out by May 31st, okay, but you don't legally have to be out by May 31st. You can voluntarily leave, or you can say, I still have legal right to possession. You take me to court. Now, no one wants to go to court, but it comes to that sometimes. And then they have to choose non-pay or holdover the landlord to bring in the court. And if it's a non-pay issue, a tenant has a right to defend against that if they owe that money, and they agree to owe that money by paying all the rent. Even if it goes to court, even if a warrant is granted, an eviction is granted, before that eviction is carried out by the marshal, and you are removed from the, and a tenant is removed from a home, even before that removal, a tenant has a right to provide all the money that is owed, and then that eviction is gone. And that's what the right, this slide is about. So that's why the resources that are available for those who are behind in rent are so valuable right now, because there are people behind in rent. If the more people that try to tap into that resource now, not wait to court, or even if they're at court, if that money comes through, then and pays the back rent, then no eviction will be granted, because there is a right to pay prior to a hearing, or even after, prior to an eviction warrant being carried out. Let's get to evictions. I'm not going to go through all of this general eviction information. I did give you a basis for which, what the landlord has to do. Again, notice is not good enough. It's the judge who is the one who makes the decision. And there are certain steps for a landlord to get into court that they must follow. And you'll see on this slide, maybe it can be made available from Hannah to whomever who wants to have access to it. But you'll see that there are very specific steps that the landlord has to follow through. If they don't follow through on any of these steps, at least on the first three slides here, first three bullet points here, then the case will be dismissed. And there's other defenses, but that will be the situation. You'll see that only a marshal can carry out a warrant, an eviction. So let's say you go to court and the landlord successfully gets, the judge grants an eviction. Well, that's the process from which then the marshal will fulfill that eviction. And the marshal will first serve a 14-day notice on the property. They'll take it from the court, what the judge signed, and put the 14-day notice on the property, literally on the property, or serve it to someone that's there. And then after 14 days, if the person's not out, the marshal can come in and remove the person from the property. So that is the process. Even after court, there's another 2 weeks at a minimum. You can see that the landlord can't do the self-help evictions. If you're served with a warrant and your landlord tries to remove you or your belongings before the marshal comes back, contact our office. Well, that's an illegal eviction. There are other examples of illegal evictions, self-help evictions, but that's one, even when a warrant is served, but then they don't want to pay the marshal to come back. We've seen that. No, here's an illegal evictions. Landlord can't remove your property. Landlord can't change your locks. I've seen all of these. Take the furniture, throw it to the side of the road. Before, can't do that anyways, but before a judge rules on a warrant, an eviction, I've seen remove the door. I've seen a wood slat on the back side of the door. Turn off utilities. That's a rather large one. The city and the legal aid organizations and the city council members meet every Tuesday regarding these illegal evictions. One of the big ones is turning off electricity or water. We also meet with RPD on a weekly basis. Since the crisis began this year, we started a subgroup that works on these issues. So these are not one-offs. People are enduring this in our community on a daily basis. Threats by the landlord, intimidation, harassment, it all falls under illegal evictions in the state statute. So if you or anyone you know that is being harassed, intimidated, physical modifications to the apartment, changes, locks, that's illegal. It's actually a misdemeanor. If the landlord does that, it's a crime. And you can see if they triple damages, what that means is let's say an individual is illegally evicted and they had to spend $500 on hotel rooms until they were able to get back in to the house, or maybe they were never able to get back in the house. Well, they can recover up to $1,500, 3 times the amount they spent out of pocket if any of these actions occur. And it doesn't need to be a change of the locks. If someone is afraid of their landlord because they came by and physically threatened them, that's illegal and that's subject to damages as well. We spoke a little bit about retaliatory evictions with our questionnaire a few minutes ago. And I mentioned the landlord cannot terminate your lease after you complain about damages. That's a big one. And if they've done so, and they terminated the lease, or if they raised the rent all of a sudden, and you think it's deemed as a retaliation for making complaints, then that's a defense in court if they bring you to court. No, my lease was not terminated for an innocent reason. It was terminated because within the past year I made a complaint and here's the proof, judge. And then the landlord has to explain that that's not retaliation, because it's presumed that's retaliation if there is a termination or an increase in rent within a year of making a complaint about the property. So it's a defense in court if you're evicted to bring this up if the circumstances support it. We talked about rent increases. There's that 5% rule. If it's increased by 5%, notice has to be given. We talk about the 90-day rule for anyone who's living in their current home 2 years or longer. 60-day notice, a 90-day notice must be given by the landlord. 60 days if someone's living there between a year and 2 years. And 30-day notice of a rent increase that's going to result in a 5% increase for anyone who's living in their apartment on a month-to-month, less than a year. So we'll get some additional rights. Hannah, how are we doing on time?
We have 4 minutes.
Oh no. All right, I'm going to just pick a couple things here. Listen, there's going to be a lot of movement probably the next year as the moratorium ends. A lot of people were having problems before this new law was passed regarding paying application fees, background checks. Listen, they capped that a couple years ago. All right, no application fees. They can charge up to $20 on a background and credit check. Don't be fooled. I still see it. People paying exorbitant amounts. 20 bucks, 20 bucks, not 100, not 150, not secret fees, $20, folks. Security deposit cannot be more than 1 month's rent. Late fees limited to $50 or 5% of monthly rent. Here's a big thing, folks. If you're behind on rent or you know someone who is and they're $50 and they're obligated to pay late fees, they cannot be evicted for those late fees or attorney's fees. They can be charged, but they can't lose their housing in court because they failed to pay the late fees. They can be sued in small claims court for that, but they can't lose their housing because of late fees or attorney's fees that they couldn't or refused to pay. Just the rent. Source of income discrimination. You have DSS, you have Section 8, you have SSI, you have some income as a vet. Landlord in New York State now cannot prohibit from renting to you. Does it happen? Of course it happens. I'm not accepting DSS. I don't want Section 8 tenants. That's what some landlords, not all, some landlords abide by. Folks, that's the source of income discrimination that's outlawed now in New York State. There are avenues to contest that. We're looking for cases where folks are, we have a fair housing enforcement project who gave a presentation. They're looking for cases on source of income discrimination. There's a administrative mechanism to file a complaint with New York State for source of income discrimination. It segregates us on many levels and makes our community less fair for all. So if you or someone you know is being discriminated against as a result of the source of income, you can contact our office. We have a special unit that deals with those types of issues, along with racial discrimination, religious discrimination, and other types of discrimination in housing. All right, I got 1 minute, looks like. Make sure everything is in writing. This is how you're going to protect yourself. Texts are good. Notices are better. But texts are good, and then that seems to be a new wave in the past decade in terms of what we use in court. But make sure it's in writing. If you have someone who's inspect the property before moving in, and you have a right to have a move-out inspection now when you move out, so that there's no issues. Know the Fair Housing Act as it states there. Listen, I gotta touch on the rental assistance real quick. All right, there's a number of programs right now, but if you want to, or you or someone you know needs help with rental assistance, for back rental assistance, call 211. All right. I know that there were issues last year. Some may have experienced issues last year with getting through and application times, but it seems to have been more resources have been put into it. 211 is the one-stop shop to get back rent assistance. Right now, they can approve up to 12 months back rent to be paid. A landlord and tenant both have to be cooperative in getting that. And the tenant has to furnish certain information like social security number, wage statements, or at least income source, proof of income source. But this is not a loan. This is a grant. It pays back rent for 12 months. It can also pay up to 3 months future rent under certain circumstances. Call 211 if you need a security deposit or first month's rent, and they'll direct you to the agency that is going to be dispersing those funds. There are millions of dollars. I was on the phone yesterday, in a call with council members in the city and then and legislators in the county. They can't give the money away. The money's there for the taking, and they, the burden's on them because it's a program that is supposed to assist the community, and the community needs to take it. There are some bureaucratic issues, but call if you or someone you know needs it, and they'll work through the bureaucratic issues with you if you hit a snag. Our office itself, I mean, we're accessible. There's 325-2520 is our general number. Our office remains closed, but we can do special appointments with folks to sit down with them under certain safety precautions. You see, I'm in the office. We're also physically in court working with folks. So on a daily basis through a project that we work with Legal Aid Society and VLSP. And so we're in court 5 days a week to handle all folks who are being evicted and have a court proceeding. So there is representation out there for those who have been given court paperwork. I thank you for your time and your attention. I'm a couple minutes over. Hannah, I leave it to you, my friend. I am open to more questions unless it's a hard stop.
It is not a hard stop. So if people do have questions, feel free to stay on and ask. So I'll give you a chance right now before we end the call if anyone wants to ask any more questions. It doesn't seem like there are any right now, but we do have your contact information. You said it's okay to share that, correct? Okay, perfect. So then I'll also hand out the presentation as well. So if anybody has any questions, reach out to me or reach out to Robert, but we'll direct you to the right person. So I want to say thank you very much for presenting. That was important information that people need to know nowadays. So thank you. Have a good day, everyone.